You know, he went out there as a police officer, and what the evidence was, Thomas was sleeping in the parking lot where he was almost run over. And when he gets there, this is the one where their security guards have Thomas in the car with handcuffs. And so he couldn't have been that violent. I mean, a couple of private security guards, and he's in the car with handcuffs on, waiting for, well, Ramos is the person who comes out. And he talks to the security guards, and he says, well, most I could do would be to give him a citation, maybe send him on his way. So if he was violent, maybe he'd be doing something else. But this is just sleeping in the parking lot. I think what happened, there's some kind of notation about him being aggressive when they told him he had to leave. Kelly, yes, sir. You need to find somewhere to sleep in that shopping center. Thomas, okay. Not here. Okay. So that was mischaracterized too. I mean, Kelly wasn't hostile to Ramos. It's not some kind of a verbal strategy that Ramos was using. It's just what it is. He went out there, and you know, and he tells him to get going. All right. This other thing about verbal strategy is the claim about the threat that Ramos made. The one, you know, about, you see my fist. Tells him he's, you know, not effing around anymore. He tried to be nice. Being nice is over, basically. This threat is one of anger, one of irritation. You know, when you think about that threat a little bit, and it's a kind of, I mean, to say that it's a verbal strategy was kind of ridiculous. Well, we'll talk about it a little bit more later. But John Barnett claimed that, well, or he said in his argument that the reason that we say that the police, or the reason that I say that the police don't set the rules, is an excuse that we've made so we don't have to deal with these two witnesses, Rubio and Sergeant Craig. But that's their argument. But the rules are set by the court. And the court's special instruction to you is that certain witnesses in this case gave opinions that the actions of the defendant or their contact with Kelly Thomas did or did not violate the policies of the Fullerton Police Department. Those opinions are stricken. You're ordered to disregard those opinions. Not my rule, the court's rule. It's up to you to determine whether the defendants used excessive or unreasonable force. Up to the jury, not the police. Based on all the evidence that's been presented in this trial, but you may not consider evidence that's been stricken. So another thing that Defendant Ramos, that Mr. Barnett did during his argument was to really chastise us for bringing an independent witness from 3,000 miles away. I don't know how many times you heard that, but they had to go 3,000 miles to get a witness. Well, here's where they went to get their witnesses. Officers, or Corporal Rubio and Sergeant Craig. They went to the Fullerton Police Department, a couple of blocks away. They didn't go anyplace. They didn't go get an independent witness. They got witnesses from the Fullerton Police Department who had an interest in the case. They didn't go to another police department in the county. They didn't go to someplace else in the state. They didn't go anyplace else in the country. There might be a lot of other places where they could go, but they stuck with the Fullerton Police Department to use those witnesses. It's up to you to judge the credibility of those witnesses. And I think it would be something that you want to consider when you're looking at their testimony and their opinions and their credibility. And you'll be asked, or the instruction will say, is the testimony influenced by a factor such as bias or prejudice or personal relationship with somebody involved in the case, or personal interest in how the case is decided? What was the witness's attitude about the case? So those are the kind of things that you use to judge the credibility. And with respect to Corporal Rubio and Sergeant Craig, I recommend you might want to look at these things. First of all, implications for their career. Now, this came up during the arguments of both counsel, Mr. Barnett and Mr. Schwartz, and they both said, concerning, particularly concerning Corporal Rubio, well, if Corporal Rubio trained these officers to get in trouble, he wouldn't still be the training officer. Sergeant Craig, when he goes to the scene, you know, he's got an interest in saying, well, he didn't see anything wrong. He didn't. I mean, you know, it's in his interest as the sergeant on the scene to say that that what he saw was reasonable. They have personal relationships with the defendants, their fellow officers, and they still work for the Fullerton Police Department. And think about that part. If Corporal Rubio, Sergeant Craig, officers from the Fullerton Police Department come in here and testify and say that that these people violated, that these defendants were unreasonable and used excessive force, and they assist in people's evidence in this case, they have to go back to work in that police department. So they have a strong reason to not say that these two defendants did anything unreasonable, anything wrong. Sergeant Craig, and you could see from the testimony that it gets kind of extreme, actually, in Sergeant Craig's view, or Sergeant Craig's attempt to claim that nothing was wrong. So when he got to the scene, it was asked of him, after seeing blood, after joining in to assist in putting your knee on Kelly Thomas's back, you heard Kelly Thomas crying for help from his dad, right? Yes. And that didn't factor into your assessment of the situation, did it? No. Okay, and he said, I can't breathe, didn't he? Yes. And that didn't factor into your assessment of the situation either? No. So when you heard those pleas of Kelly Thomas, this crying and pleading for help, that didn't even have an impact on you, did it? No. So he's not, he goes to the scene and he completely trusts Cicinelli and the other officers there to be right. He doesn't make any judgments on his own part as the sergeant, and now he's not going to admit that he did anything wrong or that they did anything wrong. Corporal Rubio. Corporal Rubio has been a police officer for 23 years. And he's the training officer at the Fullerton Police Department. And he says that he taught, as far as teaching about communication and verbal strategy, you might say, things like that. Now he's talking about what he taught Defendant Ramos. And he's saying, sir, I taught him, once again, I taught him to communicate with people effectively, whether they're mentally ill or not, to de-escalate situations. Once again, so you treat everybody, try to treat everybody, use calming language, try to de-escalate situations verbally. That's what we generally try to teach. Well, he's saying that he says that he looked at the video and he didn't see anything inconsistent with the training that he teaches. This is inconsistent with the training. If he trains people to de-escalate the situation and to use reasonable language, proper language, to de-escalate the situation, what happened here is completely inconsistent with that training. This is why it's not left to the police department to set their own standards and decide whether or not the conduct was reasonable or unreasonable. And there are some excerpts from the policy manual that have been presented in this case, but the court tells you, keep it clear, those are not statements of the law. It says you may not consider any statements contained in this exhibit as being a correct statement of the law on the use of force by police officers. So they're in evidence. There are these excerpts that are in evidence, and it has more to do with what the police officers have, what kind of training they have, what ideas they have, and it might help you to determine what would a reasonable police officer do in a particular situation, but it's not to be taken as a statement of the law. All right. So it was very important for Mr. Barnett to claim that this was not an arrest. That what happened, this whole incident where Defendant Ramos put the gloves on and then threatened Kelly Thomas, that whole thing was not an arrest. By the way, Mr. Schwartz contradicted that. He seemed to think it was an arrest because when he talked about it, he said, "Well, Kelly didn't want to be arrested," and he went on sort of that sort of thing. But anyway, that's not true. I mean, here's the conversation that took place at the trunk between Defendant Ramos and Officer Wolf. And Ramos said, "Take him for $496. $496 is receiving stolen property. Take him. Not detain him, not keep him around, not continue a detention. He wants to take him." And he makes it clear. That's what he tells his fellow officer. And why? Get a call on him every night. And then here's the next thing. He goes straight to putting the gloves on and making that demonstration to Kelly Thomas. And then he goes straight from there to making this threat. This is an arrest. I mean, you know, look, he's telling him he's going to put hands on him. He's going to take him. And he said to Officer Wolf, he's taking him for $496, or you know, let's take him. He didn't plan how to do the arrest, but he went out there and did that. Then he did this, made this threat. So he's going to take him. It's not going to be nice. This is a detention. This is Officer Ramos's detention of Kelly Thomas. Just relaxed, not worried about anything. Here's another part of the detention. If he was just going to continue to detain him, go back out, Kelly Thomas was just sitting there. He was sitting there waiting for Defendant Ramos to come back from the trunk, just sitting on the little curb. He could just, if he was going to continue the detention, he'd come out, hang out with him a little longer, and he'd be detained there. That's not what was happening. So Ramos was going to take Kelly Thomas when he threatened him. Why would Mr. Barnett make such a claim? Why would he say, well, this was not an arrest? Because of this. Because if you're making an arrest, to do it right, you have to, you're instructed in performing an arrest, the officer must tell the person that the officer intends to arrest him, why the arrest is being made, and the authority for the arrest. So this whole thing about not being an arrest is so he doesn't have to comply with these requirements. Okay, there's another defense claim about running out of options. Running out of options is not a legal justification for the use of force, for the defense escalation of force the way it was done. Here's a part of the instruction on justifiable homicide, and I'm going to talk about those maybe a little bit later, but to be justified, the killing by a public officer must, among other things, be necessary to accomplish the goal of arresting a person charged with a felony who was resisting arrest and fleeing from justice, and the person must have had probable cause to believe that the person killed posed a threat of death or great bodily injury to another. Now we're getting, when you escalate the force to the point where you're using deadly or lethal force, or you're using a high level of force that's likely to cause great bodily injury or death, you need to have pretty good reason to do that, not because of running out of options. And Defendant Cicinelli knows that. He knows that ran out of options is not consistent, at least with his training. He knows that that's not what you're supposed to do. And he's taken some tests in that regard. You know, with the training that they have, every so often they have to take an exam. These are not, maybe not terribly complex exams, but, and I don't know how many pages they are, but here's one that he took on September 14th, 2010. And this is about lethal force, use of lethal force or deadly force exam. Lethal force or deadly force is defined as, and he gets the right answer, force likely to cause serious bodily injury or death.
Objection. I think this is not redacted out. This answer.
No, it wasn't redacted. May I proceed, or? Oh, okay.
Objectors in front of argument. Last comments will be stricken.
Excuse me, may I have a minute, Your Honor?
Yes.
Here's the non-redacted version of that test. So that that prior one was blacked out. All right. At any rate, another part of the test, a little lower on the page, the use of deadly force is justified under the following circumstances, and he gets the right answer, both A and B. A is to protect themselves or others from what they reasonably believe would be an immediate threat of death or serious injury. So a police officer could use deadly force for that purpose. And B is to, in effect, an arrest or prevent an escape of a suspect, felon, where the officer has probable cause and believes that the suspect poses a significant threat of death or serious bodily injury to the officer or others. That's when you can use deadly force. The wrong answer, and he didn't get the wrong answer is when attempting to arrest a violent suspect, and and all other means have failed. So that we're out of options. That's the wrong answer on this test. This is another test that he took on November 16th of 07, and it's basically the same. This time it's B and C instead of A and B would be the correct answer, which are the same as in the first test. But here, still, when attempting to arrest a violent suspect and all other means have failed, that's the wrong answer. And also note, the wrong answer is A, when an officer is overwhelmed by fear. The officers are expected not to be overwhelmed by fear, to act in a reasonable and responsible way. Mr. Schwartz insists on this two jabs to the head idea is all that Defendant Cicinelli did. Well, you know, I mean, you've got the evidence, we've got the video in, we've got the DARs. Those are there for you to review, and of course you'll do that. And you could play it. You can play it and look at it. Go back and forth if you want to. There's no evidence. There's no evidence that there were only 2 jabs to the head. The only place that has been presented in this trial is by the statements of Mr. Schwartz. He's the only person who ever said there were 2 jabs to the head. There's been other testimony. There's been testimony by Corporal Rubio. And Corporal Rubio was certainly trying to minimize as much as he could, went from I think originally he said there were 4 to 6 when he was talking before, and then when he was asked to count them here, he got to 3. So even Corporal Rubio didn't get to 2 strikes to the head.
Objection, this is the evidence. You qualified the last one, not knowing the circle.
So what does Cicinelli say? What does Cicinelli say about what he did? Okay, the first thing he says is, in his own words, I got the end of my taser and I just probably smashed his face to hell. That doesn't look like 2 jabs to the head that he's thinking about, that he just did. This is on his DAR, and it's on that same evening that this took place, and this is what he's telling some fellow officer, whether it's Sergeant Craig or somebody else who was there that he was talking to, can't be sure of. But it's on exhibits. Well, this one's on exhibit. These are on 3, 4, and 10A and B, so you can find them. Because they show up on not just on one DAR, but more than one. That's what he said. Oh, there's a defense exhibit, which is the defense video, and I just want to let you know just want to let you know that when you listen to that, this part about what he did when he ran out of options is left out. Now here's. That's not in the defense video that you would listen to or see. Next thing he says, I beat him probably 20 times in the face with this taser. So those are his words. So you can watch. It doesn't look like 20 times, but that was what was on his mind. He was in his mind, he was beating him. He was pounding his face. How does this taser get all bloody like that with 2 jabs to the head? It doesn't. It takes a good deal more than that. There's blood. You can see it. It's splashed up on the taser. those kinds of injuries don't come from a couple of jabs. These are hard hits. There's another defense that comes up here. Another, Mr. Schwartz is talking about self-defense and saying that, well, Defendant Cicinelli was having to hold on to his taser, that Kelly was grabbing it, and it was almost slipping out of his hand. And you know what? There's no evidence like that in this case. There isn't any evidence that it was almost slipping out of his hand. There isn't no evidence about it, him being likely to lose his taser. What we have is, all right, here's the evidence of this grabbing the taser. This is what you can see. All right. What you see is, if you're watching this, you see first he hits Kelly Thomas with the taser. First he hits him, and then when he's coming up, that's when you see the hand. So he's not just in self-defense. I'm going to need to go back here. It's not self-defense on the part of Cicinelli, and this is not something where, oh, this is a weapon retention problem. This is where Cicinelli is being aggressive, and he's hitting him in the face with the taser, and he does that intentionally. He goes up there for the purpose of doing that. He sees his face. He goes up there so he can clobber him with it, and he hits him first, and then you see this arm or hand come up, and clearly Kelly Thomas is trying to defend himself a little bit. He's trying to keep himself from getting hit in the face, and he's could be grabbing, pushing, trying to get that taser to stop doing that. But Cicinelli doesn't have any problem keeping his taser. He keeps it, and then he smashes him some more with it. Here it is in slow motion. It's a lot more than 2 hits, a lot more, and they're hard hits. And it's just not a weapon retention issue. I mean, this grab at the taser in a defensive move, and then hit him some more. Where's the weapon retention part of that? I mean, it just doesn't fit with the evidence here. I mean, what is he mad at him for grabbing at the taser? I mean, we don't know. All right, now there was some character evidence, and let me just make a comment about character evidence, and that is that it can be good, and you're instructed that you need to consider character evidence, and it could raise a reasonable doubt. But the value of character evidence, the value of any kind of past conduct evidence, is that it might be predictive, or might give you some probability of what somebody's conduct might be on a given day. Well, in this case, it doesn't really mean anything. It's really of no value, because you can see and hear what happened here. So the character evidence is not relevant, really. It's not. I mean, they're not testifying about what he did on this particular day, and you can see what he did on this day. There's a claim about the cause of death controversy, as Mr. Barnett called it. It's not a controversy. I mean, we don't have a controversy here about the cause of death. You've got 4 medical opinions regarding the cause of death and 2 non-opinions, basically, what we have. Okay. Dr. Lekawa, Chief Trauma Surgeon at UCI Medical Center. He's the treating physician. And his opinion, my opinion, that during the altercation the patient became hypoxic, which means had inadequate oxygen or inadequate blood. But inadequate oxygen going to his brain and ultimately had a respiratory arrest that led to cardiac arrest in the field. That means the heart stopped. Dr. Singhania, the forensic pathologist who did the autopsy, the cause of death is anoxic encephalopathy, brain death, due to mechanical chest compression with blunt cranial facial injuries. Dr. Hugelan, the chief forensic pathologist of Orange County, and he reviewed all the findings, looked at it, looked at the videos. Mr. Thomas died as a result of prolonged mechanical chest compressions and blunt facial injuries. The video evidence for asphyxia is compelling in this case. Initially, at the outset of the altercation, you can actually hear Mr. Thomas say, "I can't breathe." A number of times, at least 7 or 8 different times as he's saying this, you can actually detect labored breathing. And you can. If you listen to the video, you can see, you can hear. When he first starts saying it, he's struggling with Officers Ramos and Wolf, and you can see what he's going through. And then later, he's loud and he's complaining and crying about it. But then as time goes on, he goes off to eventually becomes quiet. Dr. Budoff, Thomas did not die of heart failure. He died of a lack of oxygen. So Dr. Budoff is asked, is he aware that there's been testimony that Thomas died of methamphetamine cardiomyopathy? And he said, yes. Question, do you agree with that? I disagree. I don't think there was any evidence of heart failure or of a weakened heart in Mr. Thomas. As far as the enlarged heart, now, before Dr. Budoff testified, I think it was very clear that the defense position appeared to be that Kelly Thomas had this enlarged heart, large diseased heart that was weak, and that's we couldn't stand any strain, and that's why he died. But Dr. Budoff looked at it on the X-ray, looked at it on the CT scan, and said that the chamber is actually kind of small. It's normal. So if somebody has heart failure, especially with methamphetamine cardiomyopathy, the heart dilates and gets big. This is not big. It's actually on the small size for a man of Mr. Thomas's build. He would not have died of heart failure because the heart is still normal at this point. So he's explaining that he explains that there's some thickening of the walls, but it's not a weak heart. It's plenty strong for a person of his age. Shows a slide of Kelly Thomas's heart and explains, I'm sure I can't know if it's the right size or not, but Dr. Budoff is an expert, and he explains that that's about right. This is a heart that has methamphetamine cardiomyopathy. Now, this is obviously in the late stages of this heart disease, and so this is a big. You think he referred to it as like it gets ballooned up, it gets real big. So he's asked what he thinks the cause of death is, and he explains. Get to the bottom line, he didn't have enough oxygen going to his heart muscle at that time. Lack of oxygen. Talking about, and he's discussing the low pH level, and the explanation for that is ineffective breathing, as being one of the primary causes. Gives more explanation, but ineffective breathing, which has been described by him, by Dr. Lekawa, by Dr. Hugelan, and by Dr. Singhania. The defense evidence, Dr. Vilke says he doesn't know what caused Thomas's death. Now, Dr. Vilke he says, I'll be honest, I can't say what caused his heart to stop in the back of the ambulance there. He stopped breathing and his heart stopped. He went into CPR status. I don't know which occurred first in the back of the ambulance, but he went into cardiac arrest status at that point. So he says he doesn't know. Doesn't know. Now, he's saying based on his studies and based on his review of the video, it's not mechanical compression. But he doesn't know what it is. So Dr. Vilke, or Dr. Vilk is the way he pronounced it, and it goes to an extreme. He gets into sort of an absurd place in not changing his opinion and making, being the witness who sticks with his opinion. So he's talking about, and I'm taking him through the video, and and he insists that there's nothing in the video that shows the kind of compression that we're talking about. At one point, he gave this answer that, and this is when there were some questions about the voice of Kelly, where you could hear Kelly Thomas, where you could hear his voice going down on just getting longer and lower. And he says, well, it sounds like it's coming out of an obstructed airway. Then later when I asked him about that, he said, well, the obstruction implies blockage. I think it was more modification, maybe trying to explain that away. And then with some more questions, he said something about, well, maybe it's like out of the side of his mouth because his face might have been on the pavement or something. But he started out saying, well, it looked like an obstructed airway. He said he saw no evidence of any aspiration in the documentation that he looked at. No evidence of aspiration. And then when he's asked on cross-exam, he agrees that while he evaluated all the materials that Dr. Lekawa evaluated, and he agrees there may have been some aspiration. So nobody disputes that Dr. Vilk made these studies. Of course he did. And certainly he's trying to find out something, trying to get some information, publishing studies, and that's good. But they're done in a controlled environment, controlled lab, using young, healthy volunteers, laying idle in a cushioned mat. On some of the studies, they did some exercise on a stationary bicycle for like 4 minutes. And they're closely monitored by medical personnel, and they didn't suffer any trauma. And he was the first, he certainly admitted that you can't really study what happens out in the field. I mean, you're not able to replicate what happens when somebody's getting punched around and dragged and kneed and kicked. And I mean, that's just not something that can be replicated in the lab. So those studies really don't really apply. Dr. Karch, I mean, this is what started with the enlarged heart, with the enlarged methamphetamine, cardiomyopathy, weak, diseased heart. He says he has no idea if the conduct of the police did or did not cause Thomas's death. It's kind of strange. You suggested by your testimony that the encounter with the police that Kelly Thomas has on July 5th, 2011 did not cause his heart attack. I have no way to determine that. But it's hard to know what his testimony is about. He offers some testimony and then he basically says he doesn't really have any opinion. I'm saying, asking about, because he talked about these spontaneous psychotic episodes, and maybe that, and he seemed to indicate in the direct examination that, well, he had this spontaneous psychotic episode, and that's what happened. He's got the weak heart and the psychotic episode, and so I asked him, are you saying in your testimony that there was a psychotic episode, that Kelly Thomas has a psychotic episode resulting in his death? I'm saying he had a psychotic episode, and it certainly didn't make his situation better. Was it the final cause of death? I don't know. Are you suggesting in this case that Kelly Thomas was having a spontaneous psychotic episode and the police just happened to arrive during that time? Well, I think it's more than that. The police happened to arrive at that time and fight with him. So he's putting forward an opinion that Kelly Thomas was having a spontaneous psychotic episode, and the police got there, and for some reason that's why he had a fight with the police. Well, you can look at this, at the evidence, and you can see that he's not having a psychotic episode of any kind. What evidence did you see to tell you that there was a spontaneous psychotic episode? Well, there were several things that are suggestive to me. I can't imagine the situation where I would try to fight with 6 policemen. And personally, I think anybody who tries to fight with 6 policemen has to have some mental malfunction. I'm not exactly answering the question, but he's pointing to that as maybe the psychotic episode. What I'm saying is the mere fact that somebody would take on 6 policemen who are fully uniformed and equipped with the instruments that they work with, I wouldn't reckon that my odds would be very good, even if I were 40 years younger. And I'd have to think that I had a mental imbalance if I were foolish enough to try it. It's kind of an odd explanation of the psychotic episode that Kelly Thomas was supposedly having. So is this the reason why you formed the opinion that Kelly Thomas was having a spontaneous psychotic episode? Yes. I don't know. I think when you look at the testimony of Drs. Karch and Vilk, and you compare that with the whole case, with all the testimony in the case in particular, look at what happened at the time of the incident, and weigh that with the opinions stated by the other experts, it becomes very clear that Kelly Thomas didn't have a psychotic episode, and that basically the value of these 2 witnesses is not very great. It wouldn't be something that would be acceptable in this case. Additionally, he's not a psychiatrist, and he admitted that. Now he's talking about psychotic episodes and what happens with methamphetamine use, but he's not he's just not expert in that particular field. But that is something for you to think about in terms of, like, reasonable doubt. I mean, they bring these 2 this whole episode escalated into this issue where Kelly Thomas was getting weaker and weaker and unable to breathe, and eventually stopped breathing, eventually went unconscious. You can see what happened. I mean, it doesn't really take an expert to see it, but I mean, expert opinion certainly helps, and we have to have a cause of death stated by the autopsy surgeon, and there needs to be an official cause of death, but you can see it, and certainly you look at all of the things that happen, you look at the injuries, and consider the explanation of the doctors and how all this went into fit into place, and those injuries clearly are part of it. I mean, you know, the struggle, the blood, the injuries, it's all part of it. Now they claim this, there's some claim about faulty intubation at St. Jude's Hospital. That intubation error at St. Jude's, maybe that causes death. Testimony of the paramedics who actually witnessed the intubation, what do they say? Captain Stancic didn't see any difficulty with the intubation. He was there at the hospital and he didn't see any problem with it. Captain Zilgett, by the way, these paramedics are captains. So they've been around a while. They clearly have some experience. Did he see any problem with inserting the intubation tube? No. No, not that he saw. Dr. Lekowa studied the hospital records of St. Jude's. Now, Dr. Lekowa, I think you would agree, is a pretty credible witness. I mean, he called our office because he was concerned. He wanted to make sure that everything was properly considered before any decisions were made. And he had some concern about maybe he heard something about St. Jude's. He wanted to make sure that was covered. And so he got the records himself. And he found that the care given at St. Jude's appeared to be without problems. It was all done correctly. And he was concerned, but he's worried about it. Well, I guess the question is whether or not, if there was a problem with intubation at St. Jude's, would that make any difference in this case? There's no evidence that there was a problem. But when he was in the ambulance, there was a little thing there where he wanted the police officer to take off the cuffs so he could work with him, so he could give him the IVs. And there was a little hesitation there. And Captain Zilgett said, well, he ain't going to swing because he's dead. Basically, take the cuffs off so I can work on an IV. Dr. Vilk admitted that he was flatlined on arrival at the hospital. So everything they did after that comes under the heading of attempts to try to, in some way, try to keep him possibly alive, to see if they could get him to live again, see if they could get his heart going, his system going. So it's just a different claim that the defense might be making. First, their claim that he died from a heart attack, from a weakened heart, and then another one now is, well, maybe he died. Maybe it was intubation at St. Jude's. Mr. Schwartz, in his argument, said that he caught Dr. Lekowa lying under oath and committing perjury. You know, because he caught him, he pointed out, he said,
Objection, this takes argument.
I don't recall committing perjury.
Oh, I think he said he caught him lying. And he said, because he said, In fact, he was walking back. He pointed it out. And he was walking back to the podium. And he said in a very loud voice, lying. So I guess he didn't say perjury.
Objection, for the record, that was Dr. Google.
You're saying that you accused Dr. Winkleline of lying and not Dr. Lekowa?
I did say that.
Okay.
Well, I could be mistaken. I recall very clearly pointing to the diagram and saying, well, he said, and therefore I caught him lying. All right, and I'm sure everybody here remembers that. Maybe I got the wrong doctor. Anyway, just pointing out, Dr. Vilk said, before answering a question. Nobody suggested that was a lie. Stephen Rubio said before answering a question. Nobody suggested that was a lie. Mr. Schwartz characterized Dr. Singhania's statement, characterized an absurd statement where she said that 2 fingers on the shoulder could affect respiration. And here's what she said. That's not true. Here's what she said. Well, if you isolate every restriction, if you just put a restriction on the shoulder without a restriction on the leg, without a restriction to the chest, then it may not affect, but in total it will. So if all of these, like the video, you can see all of the officers here are, 3 or 4 of them are there. So they're all putting what kind of pressure? I don't know, but they all together will restrict his movement. So not 2 fingers on the shoulder. Excuse me for saying that. So Mr. Barnett talked about we didn't prove that there was not justifiable homicide. Well, you know, I would invite you to look at the definitions of justifiable homicide. Well, there's a lot of elements. I didn't want to go through the whole thing because of the time, but basically it comes down to this.